I made sure I put the AC on because I know it's hot outside. So let's go ahead and start. So today's seminar is going to be Provide and Protect, and we'll be talking about trust and estates, as well as we'll be covering a few of the finances part of it too, which will be including 401s and so forth, or whether life insurance and so forth. Today we do have three of our advisors who will be doing a presentation. But before we start, there is, let me know if you don't have a packet. In your packets, you have a few forms that we'll be discussing about today in today's presentation. Inside your packet, there is a blue form. I ask you to please complete that. If you do not want to be contacted by us, please do not put on top of it DNC, do not contact, and we'll make sure we do not contact you. This is just a copy so you can show to the Archbishop that we are out here, as well as for Father Michael, informing them who has been here. So today's seminar we have Joe, who is our attorney, and we have MJ and Rosemary, who are our finance advisors. And I'll be telling you a little bit about them. Joseph McHugh, he is, I'll talk about your school. He works for the company LA Law Center, which is located in Glendale.
Right.
Okay, and he got his undergraduate over at Cal State University of Fullerton. He graduated from his PhD.
Law school.
Law school. Oh, I should have read that more forward, didn't I? Whittier College School of Law, and his degrees of certification was BA of Business Administration with emphasis on financial analysis and Juris Doctorate degree. His home parish is Incarnation, located over in Glendale. I love that, but I'm not registered with them. Got it, love it.
Yeah.
He is a member of the State Bar of California since passing the bar the first time in 1987. Member of the LA County Bar Association, the Beverly Hills Bar Association, the Glendale Bar Association, and the Irish American Bar Association. And he's formed the LA Law Center in 2009. He specializes in estate planning matters, wills, trusts, probate, and so forth, as well as elder law, veterans benefit, business planning, and asset protection. He's been married for over 31 years. He has two wonderful adult children, a 20-year-old baby girl, but she's still your baby.
28 is the oldest one, but she's my girl.
She's your girl.
And 25 son.
Your 25-year-old son. He's recently retired as a civilian volunteer with the LA County Sheriff Posse. He has exalted rulers of the Burbank Elks Lodge, held several Metropolitan District officer positions with the Elks, and that is Mr. Joey. And now for Mary Jane. Mary Jane, she works over at Transamerica Financial Advisors, located over in Encino. And she is a UCLA personal finance planning. Her parish is American Martyrs, located in Manhattan. Grew up in Catholic church and schools, Our Lady of Peace, for grade level 1 through 8, and St. Genevieve's 9 through 12. She has two wonderful children, Christopher and Colleen, he has 3 grandkids. I mean, you have 3 grandkids with him, correct? 3, okay. And Stephanie, her daughter. She loves to travel, and her whole career she's been in the financial industry. And then we have here Rosemary. Rosemary, she works with, what was the name of the company?
I'm with WFG, World Financial.
Okay, and that is located also in Encino.
Yeah, Mary Jane and I work together. It's just that she's securities and I'm not.
Okay. Her grammar school is Our Lady of Peace for 8 years and graduated from La Reina High. Her bachelor's was over in Cal State's Mildred, CISA, and her parish is St. Euphrasia in Granada Hills. Oh. If you need any additional information, she'll be more than welcome to give you that. So I'll go ahead and pass this over to Joseph, but before I do, this will be a 90-minute seminar. It'll be open after for any questions. If you have a question during the seminar, you're more than welcome to raise your hand. But if it's more personal, I personally recommend meeting with them after. It's all yours.
The only thing I wanted to add is that I'm a product of the Catholic school system, from Our Lady of Victory. When I was in first grade, to St. Paul Across, and Marmorada to Don Bosco Technical Institute for high school. Then went to Cal State Fullerton for college. Okay. So I'm here to talk about estate planning in general. There's a lot of elements to it. I could make this an 8-hour seminar, so I'm going to only touch on things. Our goals in estate planning give the piece to the family. So what is that? Well, if you plan on how you want your estate distributed and how you want your assets handled when you pass away, then you don't have a family that could start fighting and end up tearing the family apart because somebody is greedy or somebody thinks that they deserve the house or something. So if you can take care of how you want your estate distributed, that's not just peace of mind for you having your estate in order, but it also can alleviate fighting families and maybe perhaps keep them together after you pass. I see too often that the parents are sometimes the glue that holds the family together, and as much as you can alleviate friction and stuff when you pass away, the more prepared you are and the more detailed your plan is, including maybe giving a letter of why you're leaving your estate certain ways. That does tend to keep people more from suing each other or breaking the family apart. Provide for loved ones. Loved ones don't necessarily need to be your family. You can have a lot of loved ones that you would want to leave something to. And if you don't put that down in writing someplace, then they're not going to get what you intended them to have. There are loved ones that are in your family, and you may want to benefit a niece or a nephew or somebody that's not a natural heir to you, but is eventually an heir to you. Well, that's not going to happen unless you put it down as a directive from you. Reduce or eliminate probate costs. If you do it right, you can totally eliminate probate costs. I'm going to talk about that in a minute. What probate is a judicial transfer of ownership of an asset to somebody else. It's either California that's going to decide who it's going to get transferred to, or you creating a will. But you have to open a probate up if your estate is more than $150,000. You can completely eliminate probate, and I'll explain how in a little bit. Reducing taxes. If you transfer your property to a spouse or a grandchild whose intervening parent is no longer alive, you can pass on your Prop 13 protected property tax rates. If you have a lot of an estate and you're subject to potentially estate taxes, there are things that we can do in estate planning to minimize or eliminate estate tax. I'll just say right now that I don't know anybody that's got an estate tax problem, because the exemption against estate tax is $5,450,000. And if you're married, your wife or husband also has $5,450,000. So combined, you'd have to have almost an $11 million estate before you have estate taxes. I will say though that I'm not going to tell you who I'm voting for president, but if Hillary becomes elected, that $5,450,000 is meant to go down to $3 million, which you still may not have a problem with. But it may be $3 million, anything above that will be taxed at 55%. So that's the way of reducing taxes, is that if you are going to have to pay taxes, most of my clients are not going to, we can do something within the estate planning process to reduce it. Okay, provide for incapacity. If you became incapacitated right now and cannot manage your own affairs, then somebody would have to go to court and get a conservatorship established for you. That's a court-appointed person that is going to take away your civil rights and now be able to either represent you for your financial interests or to make medical decisions for you. You may or may not want who the court's going to appoint or who's going to go seek to be your conservator. And so you can avoid that with a couple documents that I'm going to tell you about. Charitable legacy. If you have been giving to the church all your life, you want the church to benefit and provide a legacy for when you're gone, if you don't put that into some kind of a document, that's just not going to happen. And so if it's important to you, then we're going to talk a little bit about this. And there are some vehicles for being able to benefit you while you're alive and then provide a benefit for the Archdiocese when you leave. And that's what MJ and they're going to talk about that after I'm done talking. So, okay. So what is your estate? You know, most people kind of have an inherent idea of what they own. They own personal belongings, which is jewelry, art, coins, really, you know, fine china and sterling silver and all that. Vehicles, boats, and RVs are assets of yours. Homes, other real property, duplexes, income property, commercial buildings, those are all part of your estate if you own them. Bank accounts, IRAs, 401ks, stock, those are all in your name and subject to your estate. And life insurance, and I want to stop there because a lot of people don't know that life insurance is part of your estate. They're going to say, well, I was told that whoever I make the beneficiary, my children say, well, that it's going to go to them income tax free. And it does. The people receiving it as a beneficiary of your life insurance, they receive it tax free. However, it's in your estate when you pass away. So now with the exemption credit, that's $5,450,000. Maybe that's not a problem for you. If you have $1 million life insurance policy, maybe that's not a problem for you. But it was only back in the year 2000 where the exemption credit was only $750,000. And I would have people come to me and say, I don't even have $750,000. I have a house worth $400,000 and I have some investments that are $2. I'm under the $750,000. I don't need to be worried about estate tax. And then I would ask, do you have life insurance? And he said, oh, well, yeah, I have a $2 million life insurance policy. Well, he didn't have, you know, a $750,000 estate. He had a $2,750,000 estate. There was going to be major income taxes that were going to have to be paid on it. So life insurance, if it's in your name, if you're the owner and you die, it's in your estate. And like I said, maybe it doesn't matter because you might be well under the exemption credits and stuff, but just remember that if Congress drops the high exemption rate and suddenly you have life insurance that may put you over, okay? Businesses. You know, a lot of people don't think about it, but they form a partnership with somebody, they create a corporation, they create a limited liability company, or they're doing business as something, and then they die. And then who has access to the doing business as bank account? You know, what do the terms of the operating agreement of limited liability company say? Do we have to go and probate a fractional interest of an ongoing company? Okay, that's very difficult to do, very expensive to do. And by doing certain things with your equity in the business, just realizing that it's part of your estate is something that I wanted to make sure that you understood. Okay, so estate distribution. So when you pass, after your bills are paid, there's really just 3 places that, you know, your assets are going to go. I think everybody probably want the majority of their assets to go to friends and family. If you have a philanthropic, charitable intent, you may want to leave all or a portion of it to a charity. If you don't do things right, maybe that's not the right way. Maybe you really want to give your money to the government. You could do that too. Okay? But most people want to avoid paying taxes and giving their money that they have a hard time earning over their life. Just give it away to the government. So. But these are really the 3 places where I can logically think that your estate could go to. Okay, so what kind of documents should we be considering in estate planning? Probably, well, let me ask you, how many people here have a will or a trust? Well, you're a good group here. Nobody does. Okay, a will is called a testamentary document, and testamentary in Latin means afterlife, and so it really is not effective until you pass away. But it's an important document because it allows you to be able to designate somebody to be the executor of your estate, to manage your estate when you pass away, and then you're able to give direction on how you want your estate distributed. And that's a very important thing. However, it does nothing if you get incapacitated because you're not dead yet. It is only effective upon your death. And then there are some disadvantages of a will, which I'm going to talk about in a minute. So a revocable living trust while you're alive is another vehicle that you're going to find out that I really like the idea of a revocable living trust, okay? And then there's an advanced health care directive and a power of attorney. Now, those two documents are so simple to do, and you've got the statutory ones in that folder right now. I call them must-have documents. They're something that anybody over the age of 18 ought to have. And that is because I talked only a little bit about a conservatorship, but it is something to avoid. I got to tell you, it's the court appointing somebody, taking away your civil rights. And the courts don't really like to do that, but if you left a document that says, if I'm incapacitated, I want my son or John Doe to be my agent, unless there's some other reason for a court to overrule you, that's a statutory document, and banks and institutions and doctors and stuff, they have to go by that because it's a statutory law in California. So those two right there will keep you from having to have a conservatorship. And I think everybody should make a copy of that statutory form or come to me and I'll do one for you. Get it notarized to make sure that somebody knows where it's at, or give a copy to whoever your agent is. Okay. A letter, this letter is, like I talked about before, a letter of direction to your family about what you want done, first of all, with your funeral, what you want done with certain assets, notification to schools and stuff like that. You should leave a letter that kind of explains everything that you would like to say to them now that you can't, okay? The planning process. This is what I ask my clients to do. Even though I just explained to you what your estate was, a lot of people really don't even know what they have. I mean, there's stuff my wife doesn't even know, like I have, because I have like an E-Trade account that's got like $5,000 in it. They wouldn't know about it. I have Bitcoin. I'm the only one that knows how to go online and access my Bitcoin. So organizing a list is a homework assignment I always ask my clients to do. List out every one of your assets, how they're currently titled. Are they husband and wife as joint tenants? Are they a married man as your sole and separate property? And then provide that to me so that I can see what you're made of. List property and accounts, I just told you. Tell me how the property is held and titled, I just said that too. And then you need to decide what kind of an estate plan. Do you just need a will? Do you just need power of attorneys and advanced health care directives, although most people need to have something more than that? Or do you want a living trust, or do you want to create an irrevocable trust for some reason? I mean, we would go over that together once you've provided me information like this. Did you know that you already have an estate plan? All those of you that don't have anything, you do have something. It's what the state of California is going to do for you. The first thing is, if you die without doing anything, there's a principle called intestate. It's said that you died intestate. So what does that mean? Well, it means you died without a will or a trust or anything. So the state's going to decide based on a family tree that they look at to see who your closest heir is, and then they're going to stop with whatever category that is and distribute your estate within that class of heirs. So the family tree looks to see if you have a spouse or children or grandchildren or descendants, and if you do, it's going to stop with that class. But if you don't, it's going to look to see if you have parents living, and then it's going to equally distribute to them. If not, brothers and sisters, nieces and nephews, aunts and uncles, cousins. So it keeps going until you find somebody. And if you don't have anybody that they can clearly find, I would be hiring an heir search company, or the state of California, whatever county you're in, they have county administrators. They're going to look, and they may not look all that hard, And when people say, I don't want the state getting my assets, well, it's hard for the state to get your assets, but it's possible, because if they can't find anybody, they give it to the state treasurer's office as unclaimed property, and after 10 years, if nobody claims it, then it cheats to the state. The state does get your assets, right? So that's not a good plan of organizing your estate. You have to go through probate in an intestate. Somebody has to open up a probate called a probate of administration. And the probate costs, you know, an attorney doing a probate gets paid 4% of the first $100,000, 3% of the next 100, 2% of the next 800, 1% of the next 9 million. And so if you just had a $1 million estate, me as an attorney would get $23,000, and there could be additional add-on costs called extraordinary expenses that I could earn. The administrator of this also gets the same commission structure, so they would also get $23,000. So I'm happy to do that because I make way more money doing probates than I do doing living trust for people. So if you don't want to do anything, that's okay. But I got in this business to help people organize their estates and avoid things like this. So, all right, probates take a lot of time. And one thing, and wishes certainly may not be carried out because you're going under their family tree. And you may have a significant other that's lived with you for 30 years and you want everything to go to that person. And that's not going to happen if you don't do something about it. One thing I will say here is no, I'll save it for, hang on. It's coming up like now. So what is a will? A will is just a document, like I said, that says that you want a certain person or persons to be your executors, and you leave direction on how to distribute now your estate. So everybody here, while I'm talking, but I don't want you to do this, is you could do on any kind of a document, handwriting in longhand, your handwriting, you date it and you write who you want your executor to be and who you want your estate distributed to, and then you sign it. And that's called a holographic will. And it's as valid as any other will that there is. And I literally have done probates where somebody in a bar on that proverbial cocktail napkin left everything to the estate of his friend and specifically disinherited his 2 sisters that he hated. And they fought it, and we went to appeal on it, and I won. So even a napkin can be a holographic will. But I don't really think you ought to do that, you know. You can download online a statutory will in California, but if you do that, and it's not entirely in your handwriting, then you need 2 witnesses, 2 independent witnesses, not family members or anybody that's mentioned as a beneficiary. And that's a legal will in California. Not notarized, you know, not 1 signature, 2. And I can't tell you how many people screw that up. So it's probably a good idea to meet with an attorney like me in order to do, even if it's a will. So a will does not avoid probate. A will is a creature of statutory law that means that a judge has to go through the formalities of a will. You know, is an original will being presented to probate? Is there 2 signatures on it as witnesses? And the court has to prove it, and the way they prove a valid will is by going through the probate process. So all the horrible things I just talked about probate are not avoided by doing a will, okay? And in a will, I don't know why it says no children, I'm going to figure that out, but in a will you can nominate a guardian, so if you've got any minor children, that's a good thing that you can do in there. Real property in a will does not avoid probate. You have to, if you leave the property in your individual name and then in a will you say you want it to go to your children or something, you still have to go through probate in order to get that transferred. The big thing is it's not a confidential document, it's a public record. And people that are unscrupulous people that go down and find out who died and then look up and see if they've got a grieving spouse that they can go and sell something that they don't need to, you know. And there's a lot of con men around here, especially with elderly, that they will pounce and take advantage when they know that there's a will and who the beneficiaries are going to be. So a will can be searched, and a lot of people knew what John Wayne's will was, and that estate was in probate for 13 years, fighting among the beneficiaries, and the whole world knew that he was disinheriting a son, and you know, and anyway, On the other hand, Bing Crosby had a revocable living trust, which is a confidential private document. Nobody to this day knows how his estate was distributed. So wills are not, to me, a good thing. But I will say one more thing about the will. To open a probate with a will, you have to have an original document. And there are horror stories about that. You know, you could have had a fire, a flood. You could have just simply put it in a box and given the box to Goodwill or something. The instance that I told earlier was that a colleague of mine had a client who was the proverbial good son, caring for his mother and father and even an uncle and sacrificing his life. And there was a bad daughter in the mix of all of this, and a strange daughter that moved to New York 50 years before. And when the father died, who was the last one to die, the good son, being a good son, thought that his sister should come out and pay respects. Well, she did, and the way she paid respects was to find the will that gave him everything, and she tore it all up, and he didn't even have a copy of it, you know.
Oh my God.
And so, so she ended up getting half of the modest estate, and he had to share it with her, and there was nothing he could do about it, right? That wouldn't happen if you had a living trust. So, trusts. What's a trust? Well, a trust goes back to, believe it or not, Greek and Roman times. All it is a contract that you're making with somebody. You are, in California, called a settlor. Settlor, you're settling your estates. Other places call you a grantor, a trustor, but you're the creator of the trust. And you give your assets to somebody called a trustee, which is also you. So it's the second hat that you're putting on. You're the trustee of your trust. And then you are managing those assets as trustee for somebody that's called a beneficiary. Well, you also put that hat on. You're the beneficiary. So while you're alive and you've got capacity, you know, it's kind of a legal fiction. It's just a contract. So for that reason, under contract law, a copy of a contract is as good as an original. So we don't have that problem with the will if we try to do something with the trust. But when I told you wearing 3 hats, you're always wearing the right hat to do whatever you want because you're always wearing the right hat to do it. So it's like a legal fiction to you while you're alive. But if you take that trustee hat off because you became incapacitated or you died, well, then a real legal principle kicks in. You have a successor that steps into your shoes. The assets are not owned by you formally. You were just the trustee managing it. It's the trust that owned those assets. The trust didn't get incapacitated, so there's no need for a conservatorship. The trust didn't die, so we don't have to go to court and open a probate up. And so, to me, the living trust makes a lot of sense to have because it's very flexible. You can revoke it at any time. You can amend it at any time. And, you know, it avoids probate and conservatorships. It's not an asset protection tool. Creditors can get to it. IRS can get to it. However, those 2 things are very important. So if you have children, you know, you can say, when I die, I want my estate to go to my 2 children equally. However, I don't want this, I want it to be managed in a trust for their benefit until they're 30 years old, or something similar. A lot of people are concerned that if it's enough of an estate that your beneficiary is going to be overwhelmed by it, and that can just mean a couple tens of thousands of dollars for somebody, some child that is like 18 or 19 years old. It might actually prevent them from finishing college or pursuing a career because they now consider themselves to be a trust fund baby, you know. So a lot of people will say, I want it to go to them, but only if they go to college, or I want it to go, you know, in increments to them. I want to create an annuity that these guys can talk to you about, where they get an income stream for the rest of their life. There's many different things. I would be talking to you about what it is that you would want to do for your children. You can also, in a combination of a will and a trust, you can, of course, name guardians for your children. We'll talk about that more. The big thing is it's private, you know, it's confidential. It's not recorded anywhere. And so nobody knows what was in it. I mentioned Bing Crosby's estate. And it's a confidential document, so it's not published or recorded. The comment about a pour-over will is, I just told you I didn't like wills. and I don't. However, when I do a trust, we actually have to fund the trust with the assets that are going to go into it. The trust has to own it. So we have to retitle assets in your name as trustee of the trust. We have to retitle bank accounts. We have to assign beneficial interests of life insurance policies. But if we make a mistake, and sometimes how that happens is maybe you have the trust and or the house in the trust and you're going to refinance it, and half the mortgage companies won't loan to you as trustee of your trust, so they make you take it out of the trust, which you can do. They give you the loan, and then you forget about putting it back in, and suddenly the house is in your individual name, and you die. And what does that mean? Well, it means you have to go through probate, maybe. I have a way around it, but and technically you would have to go through probate. So I do a will, and the will says, I have a trust, and I'm going to try to make everything be in it, but if I made a mistake, I want the beneficiary of my trust to be, or one beneficiary of my probate estate to be the trust. So how could that happen? I've had many examples. I had people that vested in an inheritance, but because they survived their parents or whatever, but they died. They died prior to the distribution. And even though I had a living trust for them, the proceeds after the probate and being distributed is going to go to the estate of John Doe. It's not going to go to his trust that I created for him. So if it's big enough, over $150,000, I have to go to probate. And I don't want to be using California's intestate laws. I want a will there that says that, well, if I die with something in my probate estate, I want it to go into my trust. So that's what a pour-over will is. Okay. So what is a trust? There's a little visual to explain that the funding of the trust by retitling assets is like putting all these assets into this treasure chest. These are assets that are not going to be subject to probate. They're going to go and be distributed or managed however you wanted it to go to. And that's because the trusts are deemed to be owned by whatever's in that basket there. So we've kind of talked about this, but we actually changed title from your individual name to your name or names if you're husband and wife as trustees of the trust. In this case, it's the trust of John and Mary Smith, dated, February 27, 2016. We signed it today. Okay, so there's a consideration on who to name as an executor or a trustee. So choosing an executor, you're going to have to choose an executor or an administrator. And I explained the term executor is who you would nominate if you actually did a valid will. If you died intestate, then the person that's going to be appointed to manage your estate is called an administrator. It's the same job, two different names, and to make it even more confusing, California calls both of these personal representatives when you open up the probate. Okay, the next one, choosing a successor trustee of a trust. I'm hoping most of you will do a living trust, and you're going to have a successor trustee. You could have co-trustees. Kind of recommend one at a time. But that person is going to be promoted if you resign, become incapacitated, or pass away. So you need to think about, who would make a good successor trustee for you. A lot of times people want to keep it within the family. A lot of times people don't have any candidates. They've either outlived everybody or they don't trust anybody in their family. And so you could also appoint somebody that's not in your family, maybe a professional or a bank with a trust department. My personal opinion, so I hope nobody owns a bank in here, but they're not good at being trustees of a trust when they're doing banking and financial management and stuff. I look to somebody that's more personally involved, and that can be a person that's called a professional fiduciary. They're licensed with the Attorney General in California, so they've been background checked and vetted. They're bonded, and they have continuing education requirements to know how to be a trustee or a conservator or whatever. So in the last one, this morning I did this class, and a guy said, "You just solved my problem. I've been staying up at night trying to think of who should be my successor trustee." And we have a mechanism for being able to do it. We can allow a committee of people to choose somebody from the Professional Fiduciary Association. You can have my law firm do it, or you could have I don't know if your pastor would do it, or if your I don't know if your father here would do it or not. But anyway, my point is there's just a mechanism for appointing somebody if you don't have a lot of candidates, okay? Open a probate process. Well, you know, you could get a book from Nolo Press and try to do this on yourself, but you'd shoot yourself after the first month or so. And so you probably want to see an attorney that's qualified to do probate. Manage the estate, that's your job as the executor or trustee. Pay final obligations and debts, that's also your job. If the estate is big enough to have an estate tax return, well, that's your job too. And that's a Form 706, an IRS Form 706. Now, we did a lot of those back in the year 2000 or so, but when your limit is $5,450,000 or almost $11 million if you're married, we don't do very much of these anymore. But there's a caveat there, and even some estate planning attorneys don't know this. But we have a principle called portability, which means when the first spouse dies, the surviving spouse gets to keep the deceased spouse's exemption. So that means that one person has almost $11 million that they can use. But that's called portability, and it never used to be like that until the year 2012. It used to be that if you didn't utilize the exemption credit of the person that died, it was gone and you only had your one exemption credit. So we have a concept called portability, but the only way that you get to do it is to file a 706, even if it is not needed to do, because there's a box on there saying, do you want to elect portability? And so a lot of people with estates that are well under $5 million, but you know, maybe combined it's $6 million or something. It's way under the $11 million, but it's over what an individual one is, and so they do a 706 even though it's not necessary, just to check that box about portability. So that's what that references to. And then, of course, the final thing is distributing the estate. So if you had a will, a court's going to order the distribution per the terms of the will. If you have a trust, you don't have to go to court. You do have to give an accounting to the beneficiaries. You have to give notice to the beneficiaries or anybody that is a legal heir in case somebody wants to challenge the trust. And then, of course, there are challenges that the person disinherited them and that they didn't have capacity, they're subject to undue influence or something like that. So you have to give notice to people. Hopefully none of that goes on, and you just simply get the approval of all the beneficiaries, that the accounting is right, and that their share calculation of the distribution is correct, and then you terminate the trust and you give them their inheritance. Yes?
I don't know, I'm sorry, I don't know if we can interrupt you or finish all this session and then ask questions.
I kind of like it now because it's fresh, but you know, I don't know what you guys.
That's fine.
Okay, so go ahead.
Okay, in terms of that, you said the heirs, they had the agreement. What if that administrator don't even share in black and white as what are the inheritance of the siblings?
So it's not such a great honor to be a successor trustee, because it's, first of all, it's a job, and you've got what's called a fiduciary obligation to the trustees, I mean to the beneficiaries. If somebody finds out that they were not told that they were a beneficiary or they didn't get a copy of the trust, when a person dies and there's a trust, there's a probate code statute that says you have to provide a copy to the beneficiaries. So when I said it was confidential, it's not confidential to the beneficiaries. And so if they don't do it, then a court can remove them and they can surcharge them for not doing their job.
So the question is, how do you do that to get to the court? Because the heirs don't have money to bring it to court. Right now, it's happening. That's why I'm questioning.
Yeah, okay. Well, I would probably talk to you individually. There are attorneys that might do it on a contingency basis because the court will penalize that trustee with sanctions.
4 years.
Yeah, well, we should talk about that later. If that happens, and that's why there are attorneys like me. But, you know, what I'm expecting is that that's more rare than it is, you know.
No, it's not.
Okay.
Because that's the thing. I called the lawyer who executed the living trust, and the lawyer, I said, there's a fraud because I was assigned for administrator, and my brother was telling me, no, he couldn't even produce the living trust, and I have the original living trust.
Well, you should be okay.
No, but what happened is, when I called the lawyer who executed it, he said, then you have to hire a lawyer. That's what he told me.
Okay, we're in too much specifics
Yeah.
here. See me afterwards.
Yeah.
Maybe we'll get the questions after.
Yeah, afterwards.
Yeah.
Afterwards.
Okay. Anyway, minor children, does anybody in here have minor children? Okay. Children present an issue for many reasons. One is a guardian for them, and you should, if you don't do a will or a trust, then you could just nominate a guardian. Issues come up, like my wife and I, our kids are now adults, but when they weren't, we didn't want anybody in either family to be raising our children. And we had some friends that shared our morals and had kids the same age, and they were just our best friends. But they would not stand on any priority list if both of us were to be either incapacitated or pass away. And it would have been my family fighting each other, for who wants to raise my kids, and I didn't want any of them to do it. So leaving a direction as to a guardian is very important. You can't, if you're separated, you can't, eliminate your biological other parent. However, if something happened to both of you, or if there was something really wrong with the other parent and they shouldn't be a guardian, the court will look to you or direction. So, excuse me, you can just do a nomination of guardian. You can also, in a will, which is where I always put it, you can have the guardian language in a will. But it's really important. Now, the other part of minor children is that a child under the age of 18 cannot receive an inheritance. And if you don't make some other allowance for that, somebody, even a biological parent, would have to go to court and be made a guardian ad litem. The court's then going to put it in a blocked account, but then they're going to give it to them when they're 18. And, an 18-year-old receiving an inheritance, the way they spell that is C-A-R. They're going to go out and they're going to buy a big car, or they're going to do something, and you may not want them to do that, but the state's going to give it to them when they're 18, or at the most when they're 21. You may want it to go into a trust that springs up upon your death for their benefit, with a trustee that's got the discretion. It's not a blocked account. The trustee can use it for health, education, maintenance, and support. And so if you did nothing, then you wouldn't be able to say when the child's going to do that. I may have said earlier that there are people that think that a large inheritance would ruin somebody's life, and I've got a lot of examples of that. So they don't want them to have it until the trustee realizes that they're ready to give it to them. So, they basically say they're never going to have a right to demand it. The trustee is going to use their discretion to provide for health, education, maintenance, and welfare. They have the discretion to give it all to them at one time, or never if they become drug addicts or something like that. So what you do is you leave a letter of direction to that trustee and say, listen, I want you to give them everything that they really need, take into consideration all the other stuff. I want you to encourage them to go to school and get good jobs and stuff like that. Have the trust pay for education, maintenance, or medical and everything. Give them a car every couple of years. But, don't distribute it to them until you think it's time, or when they're 62 years old. Something like that. But I've had clients say, okay, I want to have them have it, you're going to do all that stuff about taking care of them, but you're going to give them a distribution every year that's going to match their 1040 income tax return, the gross of it. So it encourages them to go become a doctor or, make a lot of money, and then you'll get the same amount in the distribution. So there's all sorts of creative things that you could do. But this is all about children, and really, if you have children, even if they're 18, 19, you may want to consider it being in one of those, I call it general needs trust, and then say, oh, maybe they get 1/3 of 25, 1/3 of 30, 1/3 of 35, or something like that. Okay.
Can I just ask a quick question on that?
Yeah.
Just if you're divorced and you have full legal custody, can you name someone else other than the biologic father?
No, I mean, if the biological father's like in prison on drug charges and stuff like that, then probably you can name somebody else. But if there's nothing really wrong, and just because you've got the full custody, the court's going to immediately look on this priority list at the other biological. But that doesn't mean the court's going to award it to them, since they have not had the full physical custody and may not be a part of the child's life. Then they're going to look for a reasonable alternative. So if that reasonable alternative wants to go to court, if you've nominated them, well, they are, maybe even equal with with a biological parent that's not been a party in the person's life. But if they're a good dad and they're, you got full legal custody, but what about visitation? Is your spouse equally visiting and stuff?
No.
Well, then you stand probably to, the person that you named as the guardian is likely to have equal weight in court. They're going to lean towards the biological parent, but if there's enough testimony from other people saying this person's not involved in the child's life, they're not going to just force, your
I'm
child.
trying to get him more involved. I'm
Okay.
hoping that it wouldn't be an issue, but at the current moment, it would not be a good.
Okay, well, good luck. Okay, let's see. Oh, okay, and in inheritance structure. Well, I kind of talked about this in the idea of a child, but but there are other ways to do this and other needs to do this. Let's say that somebody is a spendthrift and you want to make sure that they have an income stream for the rest of their lives. Well, you could, and these guys could talk more about what annuities are and stuff, but you could say that if they want to invest in an annuity, that based on whatever that person's age is going to give them $2,000 a month for the rest of their life, or something like that. You can, and that's several of these, stretching it over time, a principal income deferred principal, you could just say, okay, I'm going to have this principal here, and whatever the income that comes out of that shall go to the beneficiary, but they can't deplete the principal. And then at 62 years old, they get the principal, or something like that. These are just examples of different types of things. You can just simply give it to anybody all at once, outright, with no restrictions. So I can pretty much do whatever if you come to me with concerns and we talk it out, I can pretty much figure out a distribution plan that's going to fit what your concerns are. Okay, property ownership. So when you're talking about real property, you're going to have to hold title to it in some fashion. I'm hoping you're going to have it in your name as trustee of a trust, but there are other ways to hold it. Joint tenants, where you can, first of all, you can own it individually. There's nothing wrong with that. You can actually be married and own property as a married man or woman as your sole and separate property. So you can own property and you're just in your own individual name. The second way to do it is as joint tenants. I see about 99% of the real estate agents, they have their clients take title to it as husband and wife as joint tenants, maybe with right of survivorship. Okay, everybody kind of knows that, and that just means that when one of you passes, that the other one now is the 100% owner of the property. It doesn't have to be a husband and wife. I mean, I could be a joint tenant owner with you on a piece of property or a commercial building or something like that. And so that means, though, that when I die, he's the 100% owner, which may not make my wife real happy about it, but that's the way joint tenancy works, right? Tenants in common is the way that probably we should have owned that. And that is that my interest, if it was 50%, stays with my estate, so that if he and I were on the title as, I don't know if you're married now, married men as their sole and separate property, as tenants in common, it means my 50% interest stays with my estate and is going to go by way of my will or trust or however I want it to go to. Community property is a lot like joint tenancy, and it just, it of course means that there's a husband and wife involved in it, or husband or wife and wife, or, and it means that it's a community asset, so that when one of them passes away, it's 100% owned by the survivor. Okay, you notice I've been talking about living trusts in this. This is the way people hold title to it. And if both of them were to pass away, we would be going to probate, probably intestate, on two estates to figure out where those assets are going to go. So it's important, there's a concept here I want you to understand. If you guys own property as husband and wife as joint tenants, or if you're going to buy property and you're married, buy it first in your names as husband and wife, it's community property with right of survivorship. And it's because that there is a step up in the basis that you bought it for if it's held by community property. I'll give you an example. My parents have bought a house for $20,000, and it's worth probably $620,000. So if they were to sell it when they were alive, then the basis of $20,000 versus the selling price of $620 would show a $600,000 appreciation. If they didn't have any exemptions against that, and you do if you're married and you live there until the last 5 years, let's say it was income property and they didn't live there, they would have to pay about 33% of that $600,000 gain as capital gains tax if they sold it when they were alive. So if you hold it as community property with right of survivorship and one spouse dies, you get to enjoy what's called a double stepped up in basis, meaning that $20,000, that's the figure for calculating capital gains, will get increased or stepped up to be worth the value of the property at the time of the first person's death. So it would be worth $620,000. So if the surviving spouse wanted to sell it, there would be no capital gains. If they hold on to it, there'll be another step up in basis when they pass away. And again, if the beneficiaries sell property shortly after and it doesn't appreciate, there's no capital gains. That's not the same for joint tenants. If somebody dies as a joint tenant, you don't get that full double stepped up in basis only on the part of the person that died. Because the people don't know that your husband and wife, it could be me and the guy in the blue shirt here, you know? And if I pass away, the basis of $20,000, or my part of it, which would be $10,000, would get stepped up to be worth, if it was $620, it would be $310. But then if the other owner decided to sell it at $620, there'd be a big capital gains tax. So if you're married and you have property as husband and wife as joint tenants, I don't know if it's worth going to an attorney to transfer it into you as community property. But I actually think the next time you refinance or if you buy a house and you're married, then do that. Now, if I put it into the trust, I make sure that the underlying title going into it is community property. So if I had a deed from you and it was husband and wife as joint tenants, I say on the deed transfer into the trust, despite the former title of joint tenancy, the grantors agree that this is community property and shall henceforth maintain its community property interest or whatever. And so I didn't want to get off on taxation and stuff, but that's pretty, if you got property and you've owned it for a long time like my parents did, that step up could be really very important. Okay? How to include bequests. Well, what bequests are is another word of a gift to somebody. Okay, so, and in our case, what we're hoping is that you're going to want to leave something to the church, but it doesn't have to be to the church. It could be your wedding ring to your niece, or your coin collection to your nephew, or something like that. But anyway, how can you do a bequest, right? Well, you can say, upon my death, as soon as practicable, I want a fixed amount, like $10,000 or $100,000 to go to a person, the church, the Red Cross, whoever. That's called a fixed amount. Specific property, logically, you probably know that it's you're given something. You're giving that coin collection. You're giving that ring. You're giving that. A lot of people have given their houses to churches and charities. But after you've given away what you're going to give away in the form of bequests, then you're left with a big pot of assets, and that's called a residual estate. And so I don't recommend, giving, in the residual estate, I don't recommend giving dollar amounts because there may not be enough dollars there in order to distribute out of that. I had a client that had left 22 different Catholic charities and a niece and 2 nephews. And she gave it in dollar amounts, but she thought she had $5 million and she had $3 million. And we had to go to court and litigate for some financial elder abuse. So all these guys that saw in the trust that they were going to get $50,000, they, we're still struggling with the lawsuit. And so there's not enough money. It's called ademption when you don't have enough money to be able to give out what you wanted to people. So I always recommend doing a percentage. If you say I want 10% to go to the archdiocese, you know, that could be $1 million or it could be $10,000. It kind of depends on what's left, you know. And since the specific gifts come off the top, you might give away, you may overgift, and the residual beneficiaries that you wanted it to go to are not going to get anything. So I like doing percentages, and so the residual estate is what's left after you pay all your final expenses and you do all your gifting. Okay, so what's the contingent bequest? Well, that just means if you, let's say that you say, well, you know what, I want everything to go to my son, but if my son predeceases me, then I want it to go to the archdiocese. In that case, the archdiocese would be the contingent bequest. Okay, so that's what the bequests are. Personal property list. In my trust, what I do is I have a paragraph in that specific gifting section, and it says, if I leave something called a personal property memorandum, then what I want to do is I want it to go, I want the trustee to look and see if I left that direction, so maybe I want my coin collection there to go to my nephew, and honor it. It's not in the trust, it's in an exhibit attached to it called a personal property memorandum. And so the thing to do would be to make a list of everything, because I don't know that even you know all the stuff that you actually own, you know? And you may have passwords for Facebook and all sorts of other things. You may have passwords for online bank accounts, and you know, like I do Bitcoin, and my wife has no clue as to how to enter online into my Bitcoin account and get it transferred to a bank or something. So I have to leave direction, you know, for somebody to do that. So this starts with a good housekeeping thing of listing all your personal assets, because these things are not registered or titled or anything. Now, when I do a trust, I do an assignment of your personal property so that all of this stuff is transferred to the trustee so that the trustee can honor your wishes if you start giving this stuff to them. And some people, I gotta tell you, the personal property stuff is one of the most litigious areas of stuff that I do, because there are people that will go to the Met for their grandma's cookbooks. You know, they'll spend tens of thousands of dollars. You know, family photos. I mean, I couldn't satisfy a family by taking the photos and making duplicate copies that you couldn't tell the difference from. They had to have originals and stuff. So the thing about it is, if somebody wants, you know, the great-grandmother's wall clock or something like that, and you want it to go to a specific person, you need to have a list, maybe a photograph of it, and say, I want this person to have this. Some people go to Home Depot, not Home Depot, Office Depot, and they get little colored stickers, and they say, all the red ones are for Jackie, and all the blue ones are for John, you know. It's kind of silly, but I did have a woman that had a very expensive collection of Middle Eastern and African artifacts, and she had about 10 friends that she wanted. There were several thousand of these artifacts, and she had 10 friends that she wanted to have different ones go to. And she took the trouble of doing a list and photographing them, and she had an Excel sheet, spreadsheet with columns as to who got what. I don't know how long it took her, but it's part of her trust estate, and she's happy that, you know, she did that. So, okay. Advanced Healthcare Directive, and I'm going over it. So I told you it's one of the must-have documents. It provides for your capacity for somebody to be able to make medical decisions for you. And so in that respect, you should pick somebody that would be a trusted, you know, person to do that. You know, my daughter, my wife is my agent, but if something happened to my wife, you know, my daughter at 5 years old could be running the Army. I mean, she's just very focused and straightforward, but I would not want her to be telling me that I can't have a drink of whiskey when I'm 85 years old, right? And so my son, who's a lot more emotional and loving, will be taking me out to the bars, and, you know, on my day out of the home. My daughter wouldn't be. So my son's my agent, and then my daughter. On the other hand, for the power of attorney that's coming up here, it's my daughter and then my son. And so these are things that you just have to decide on your own. But again, there's a whole statute in the probate code that says what your agent has the power to do. And basically your agent has the power to, be able to make medical decisions, and that includes pulling the plug. We're going to talk about California, the Archdiocese or the Catholic Church issue of euthanasia. But that's where, if you wanted to leave end-of-life decisions about how, pulling the plug and stuff like that that's the document that has that in there. Okay, so this is Catholics. I want you to understand, because a lot of people don't really know what the Catholic Church thinks about euthanasia. As you can imagine, they don't like it. It's not permitted. Euthanasia is the killing of somebody, but it's not exactly what you think. In Oregon, they have a right to die law, and we adopted a version of it here in California. So in January, you can go through a really onerous process, but we have the right for you to kill yourself with either an injection or pills or something. And the Catholic Church does not agree to that, okay? And I don't know anybody that's going to be able to go through that process, because it takes, you wouldn't believe what it takes in order to be able to get those pills or that shot. And you have to administer yourself. So if you don't have the ability to take it yourself, you can't do it. So I'm not here to teach you about that. What I'm here to say is that the Catholic Church recognizes, first of all, every life is valuable, and every life is beautiful and should not be taken. But death is a normal part of the human condition. Killing somebody is not a part. Life support, though, is not always mandatory. Like, if you think the Catholic Church wants you to be hooked up to machines until you can't be cared for by machines, that's not their preaching. If you are brain dead or you are not benefiting from being kept alive, you can pull the plug. And a lot of people don't really know that. Pain relief is another thing. The morphines and the other pain relievers, it's not against the Catholic religion for you to be relieved of pain, even if the medication hastens your death. Okay, not meaning overdoses and stuff, but just that it shortens your life. Food and water withholding, the church is against signing something that says that you don't want nutrition and liquids and stuff like that. Again, though, if you don't have the quality of life that the food and nutrition are keeping you alive when you're brain dead or then it's okay to withhold this. But you have to understand whether or not it's helping them, I guess. Medical and spiritual advisors, well, certainly if medical advisors, if you're on hospice at home or if you're in a hospital, medical advisors are there to tell your agent what the quality of life is of that person. My father was dying of cancer, and it came kind of quick at the end, and his organs were shutting down. And the doctor just said, his kidneys have shut down, all of his organs are shutting down right now. He would be in such great pain if we were able to keep him on pain medication, or pull him off of pain medication. Right. And so basically he wanted to go home, and we put him on hospice, and he died a few days later. And that was the medical people telling us what his quality of life was, and that he was never going to come out of the coma. Spiritual advisors, of course, the parish priests that come and do Eucharist and the homes and stuff, those are very valuable to people that are faithful to the church. But I've also just seen hospice people that will send some clergy or some ordained minister who will explain the death process to somebody in such a way that it actually makes the grieving family feel better, because they kind of understand that it is a process, what's going to happen. And so getting any kind of spiritual advice is always a good thing to do too. And then if you want more information, there's a pro-life, it's a website that's dedicated to what I've been telling you here. Now, the power of attorney. That is another important must-have document, and it means that you've designated somebody that can step into your shoes and represent you. In this case, it's about financial and administrative. If you have everything here in that treasure chest in the trust, then we're not talking about your agent doing anything with those assets because the trustee's managing those. And so that would mean that this agent under power of attorney is dealing with IRS, Medicare, Medi-Cal, Social Security, but more importantly, insurance companies, cable TV companies, electrical companies, or bringing a lawsuit if you're unconscious because of a personal injury or something like that. So basically, they stand in your shoes, and they can do everything that you would have done if you were going to bring a lawsuit or get the premium cable package added onto your bill. Or I'm just kidding about that. But, okay, so you should, if you follow my trust concept, you should have everything in the trust. But some people keep accounts in their own individual name because they don't want the trust involved in it. Maybe they made the trust as a beneficiary, but they're still alive. Now, somebody has to go to that bank and get in charge of those assets, and that would be your agent here. Okay, let's go on. I kind of said this before, but inventorying your assets is just an important thing to do to figure out whether or not they would be subject to probate and they need to be protected in the trust. And then you have a general sense of what your estate is so that, unlike my little old lady that over-bequested to 22 Catholic charities, you actually have a realistic idea of what your estate is that you want to distribute to people and then how you want to distribute to it. So I think my talk is done until afterwards when you want to ask questions. So I'm going to turn this over to these guys.
Good.
Just push that button and we'll go forward.
Thank you very much. I'm Rosemary Langrat, and this is Mary Jane Wagner, and we are here to go over some of the insurance and annuity aspect of the planning. And we'll both be talking a little bit, but we're talking about life insurance and its use for estate equalization. If for people who have large estates, and if their life insurance can be used to offset some of the costs that would have to be paid to the state because of the high amount of inheritance. So that's one good use for life insurance, which a lot of people don't really think about. We all think about life insurance as just a product that will protect our families if we're no longer here, but they're much more than that. For IRAs, 401ks, 403bs, do you want to talk a little bit about that?
Yeah. As far as tax advantage plans, those are taxable as we receive them when we turn, say, 59 and a half, or when we retire. At some point, we have to start drawing down on them. Now, there's ways to make that more tax beneficial. And that is, over the course of the evening, we've been talking about planned giving. We can make a gift of these things to our church or a charity of our choice or a foundation of our choice. And then as far as an annuity, we can have an annuity structure built into that gift. So then we get some tax benefits and we can have some income. And our charity or foundation will benefit. So that's one way of looking at it. All of these items, the IRA, the 401k, and the 403b, are structured to provide you with long-term income. Doesn't matter the size, it's obviously preferable if you build those assets, but it doesn't matter what your size is. You need to be aware of how to make those funds last and enhance your retirement years. That's what they're geared for. As far as real property and tax advantage, well, owning a home, I am not an accountant, so maybe I should leave that part, but real property can be gifted to a foundation or a church, as you please, or keep it in the family, whatever you choose. But in this case, we're discussing foundations and churches and charities.
I think I can add something there, because I have a lot of clients that own many different pieces of real property, and they're tired of being landlords. And if they sold all this real property and retired on it, they would pay an incredible amount of capital gains tax. However, there's a thing called a charitable remainder trust that can be set up, and if they transfer it to the trustee of that trust, which they can be the trustee, then they sell it. But there is, when you create the trust, you have to have a 501c3 charity listed on it, which could be the Archdiocese or the foundation she's talking about. And during your lifetime, you get the income stream from that money. If you had sold it, you would be, less the capital gains, but you have the entire amount in an annuity or something. And that income stream, when you goes down through your lifetime, maybe through your spouse's lifetime, when you die, it goes to the church if the church is the beneficiary. You not only get that income stream, but you also get an immediate tax credit for the donation that the IRS thinks it's going to get when you pass away. The IRS assumes that whatever you put in there, that 10% of it is going to go based on your life expectancy to the charity. So in that first year, when you give assets, you could get a big donation that's so big that it's carried over for the next 5 years off of your current income taxes. And you can benefit from that income stream without having to have paid capital gains, and you can satisfy your philanthropic obligations by dying and letting it go to the church. So anyway, that's a charitable remainder trust, and since you didn't know the tax benefits of it, I wanted to explain.
Right, and
Oh, okay, I was going to say, as far as the property goes, yes, you can donate the property, and again, you don't have to give 100% of anything to a charity or a foundation. And you can structure, you can sell your business through, you can give your business. I have one fella who's giving his business to the charity of his choice. He's already got the buyer aligned because the charity will not keep the business, and they're gonna sell it, and he will have annuitized income for life. If he had straight out sold his business, let's call it $1 million, he would have had a huge tax issue. So these are some of the things that you can do to eliminate or minimize or help you with a tax issue if you feel like you may be having one. Again, check with your accountant on all of those things. From our point, we help structure the annuities, we work with the attorneys, we work with the accountants, the person that's selling the property, the person that's selling the business, or a family that just wants to make a gift.
right, and I wanted to bring up on annuities as well, and I know Mr. McHugh mentioned this quite often during his presentation about how, if young people are left a lot of money, usually what they'll do is go out and buy a Porsche or, something ridiculously over the top because, at 18 and 21, yeah, that's what you do. But, putting money into an annuity for your child is also another thing that could be set up so that there would be an income stream for the rest of their lives. So there's...
What is an annuity?
An annuity, most simply put, is money going into a bucket and then the bucket paying out over either a specified time frame, a lifetime.
And you can't lose on it. It's not putting your money into the stock market, it's in the index, so you won't lose.
It is an insurance product.
Right, so
So
that's
that's
insurance
where
product, and it's, and it's highly insured, so that.
Highly regulated.
Regulated and insured, and so, it's just a great, and a lot of, people don't think about it, but it's a product that people can use to protect their families, and then, and I think that our Sally will talk about, a little bit of what the church, what they propose as well. So, let's see here.
Appreciated stock also. We've done that over the years for different schools where we had accounts and helped their foundations. And families would donate stock to the school, and then the school liquidate, then we would liquidate on behalf of the school and give them the funds. So again, it's another way for, it's a tax issue, you know, if your stock is greatly appreciated and you may not want to pay those capital gains taxes, there's a way to eliminate that.
Okay, and this is a little bit of what we've already talked about. A lot of this really is something that a CPA would be, you know, so as you're putting your plans together, you know, we recommend that obviously you see an estate planning attorney who will help you put everything into a trust, because it is so important. People like Mary Jane and myself do the insurance part of it, and the, you know, and if you know, anything that has to do with putting money into annuities or, you know, structuring it for the future, that's what we do. And then a CPA would, you know, would help with your tax implications and you know, what you should and should not do. Basically, we've already talked a little bit about, you know, giving to charity. It's another option for people who, you know, want to leave something to their church or leave something to a particular charity. There's a way to do it so that your family can enjoy the money, and then it is at some point left to a charity. And this, I think Araceli will talk a little bit about this, unless you want to go over it.
Oh, this is going to be more like a path where you can share money with your family, money going to a charity, and then also how the money comes back and back into the family after a certain time frame. So it's things you need to sit down, talk to financial advisors, attorneys, and CPAs. Tell them, I want to make gifts, I want to make sure my family's taken care of. You have to tell them, what are some of your ideas? Not just, I have a house, I have 4 kids, and 2 ex-wives. How do I take care of this? You have to tell them more about some of the things that you want to do. Ask questions, plan ahead. One thing I look at, compare the whole process to, between the attorneys, the estate planning attorneys, the accountants, and the financial advisors. Think of a jigsaw puzzle. We are putting the pieces of your life together to make a complete picture. And it's a lot of pieces, and it's not done in the snap of a finger. You've got to be careful and ask a lot of questions. Make sure you get your bases covered.
And if we, go ahead.
I just wanted to explain that slide because most people don't really understand. I told you earlier about a charitable remainder trust where you can put money, you can get an income stream, but if you got hit by a truck, everything goes to the charity. This is called a charitable lead trust, at least that $300,000 one right there. It just says that it's in trust, the charity's going to get it when I die, but I or my family are going to get the income stream until I pass away. Okay, and so that just means that it could go over your life, it could go over your children's life, but then whenever that terminates, it's going to go to the charity. Okay, so it's different than the charitable remainder. It's called a charitable lead, where everything stays with your family until you die.
Right, this is your base amount. You're giving the family X amount on the front end, and then here's your what you're going to be giving the charity, the annuity structure, and then it comes back and pays the family for those 20 years, and then they get the leftovers, the remainder.
The way it's supposed to work is that 300,000, that income stream that's going to be coming to you, never reduces that 300,000. You're living off the income stream, which depending on the annuity and the interest and stuff that you get, could actually add to that principal to go to the charity. But anyway, it's taking care of your family, but also the principal is going to go to the church or the charity when you pass away. So.
And other folks too say, oh yeah, well, it's great I'm giving it to the charity. I need some money to live on throughout my life, so I need this 300,000 income. But what's going to be left over for my kids? Sometimes folks will even get, for discussion purposes, like an insurance, life insurance, and that will pay the family down the end, and they get the charity gets your remainder. So there's lots of different ways to get things done. And it doesn't matter if you have, 100,000 or 50,000 or a gazillion. Talk to your attorneys and financial advisors and CPAs.
Right. And the last thing that I'd like to mention, and we haven't discussed it yet, is that in doing all of this, long-term care is something that should be thought of as well to kind of put the whole thing in a circle, because statistics show that 1 out of 2 people will need some sort of help later on in their life, and that is something that can be structured also through a life insurance policy. Life insurance policies are very different. We have what's called universal life policies, where there are different buckets. So if you want to just leave the whole $500,000, let's say, to your family, it's there. But in the meantime, it's also growing tax-free, and that is money that you can use for your retirement. At the same time, if you need a bucket for long-term care, you can use it for that as well. And that is a really great product. There's also standalone long-term care policies. Some people may want to go that route rather than the insurance route. That's available too. So there's.
I hate to keep interrupting, but I can't press enough the long-term care portion of this. And I don't know if there are products now that are kind of a hybrid or combination of life insurance and annuity and the long-term care. People hated to have to pay an annual or monthly annuity, and then if they didn't need it, then the insurance company won. But based on what your age is and everything, if you had a lump sum amount that you could put down, like $100,000, then you might get up to $500,000 worth of long-term care coverage. If you never need it, it comes back to your estate with interest. If you need that premium back, you can take it back. It's the most versatile kind of product, but you need that $100,000. So I tell my clients, if they're receiving an inheritance from their parents or something, well, put $100,000 of that into it. But my typical client has a house that's worth about $600,000, and they've got maybe $200,000 to $400,000, usually in very conservative investments like CDs, not earning anything. And if you can take $100,000 of that and put it into one of these policies, they earn probably 5% or something. I don't know.
More than the bank.
More than the bank. And if you ever needed it back, you can get it back. And I say, like that typical client, they're not eating into that $200,000 or $400,000. They're living on their pension and Social Security. They got their house paid off. So, I mean,
But also for people who, if that $100,000 seems too big to you, and it could to a lot of people,
yeah.
You don't have to start these policies with that. I mean, you can, start a long-term care policy through an insurance policy just by starting it. It could be as little as $200 a month. It depends on, or even less than that, depending on your age. I mean, if you're younger, obviously it could be, we can start it for $100 a month. But, it's there, and you put in as much as you'd like, dependent on what you can afford. And then if you can go in with a lump sum of money, that's great. But if you can't, there's ways to protect yourself, and you put it in as you go. And that's what Mary Jane and I, do. And as Mr. McHugh is the legal expert here. We do the insurance part of it, and our cards are around. And if you have any questions, we're more than happy to sit down with you and go over things. And there's no obligation. It's just a free, one-on-one to answer your questions.
One
So-
last thing about long-term care, it is the biggest, the largest consumer of estates nowadays. That is, it'll double up at 4,000 is very modest, and it can easily go up to 10,000 a month. So think about those things. Again, nothing costs you if you ask a question, but it can cost you a lot if you don't ask questions and you get into an issue. So anyway, thank you so much. I sincerely appreciate your time this evening.
And I'll try to wrap it up, I know it's coming already at the 90-minute. I know it's a lot of information you got today.
Sure.
It could be a little bit overwhelming, just to say a little bit. But I will tell you a little bit about the annuities, as I have, somebody had a question in regards to it. Inside your booklets, you do have an annuity information sheet that is offered by the Archdiocese. In the back, it does say the percentages. So the older you are, the more you get. If you're 90, you get 99% back from whatever you have given. It's pretty much, I call it a little gamble, because last month, I'll just say, for example, just a legacy member that we had, last month he passed away, he was 102. So for 30 years, we were paying him out monthly a certain amount from his annuity. So it really depends on the annuity you give. If the minimum is 5,000, it could go up to whatever you like. But depending on the amount you put in, you will get it either quarterly, yearly, or monthly. So he was getting this amount until the day he passed away. And this, like they mentioned, it is something that is set. It's not like the first 30 years and that's it. No. If you end up, because for example, that member, our legacy member, he was 102. So his annuity was actually already in the negatives. We were actually giving him more than he had put in. So that's why I say it's a gamble, because you can take it. And then another thing too, that there has been actual statistics showing those who have annuities live longer, because, well, you have that check coming in, so you pay, your rent's paid, so hey, why not stay another month? And so, yeah, so I'll wrap that up. Also on the other one, sorry, last one, if you are, this is something that we have added this slide because we have actually come around and finding out there is some who have informed us that they already had added something to their, they have added either parish ministry or school into either life insurance, trust, or estates. If you like, you're more than welcome to let us know that you have, and you will then become automatically a Legacy Society member. We do have some events that go on every year and where we thank you, because one thing we want to do, we want to thank you while you're alive, and of your gift and having the parishes, school, and ministries in your thoughts. So I'll wrap it up now. So it's pretty much a summary about Rosemary, MJ, and Joseph of today's presentation. With the presentation, you do get a free consultation. So those people who slipped out, I did not get these signed for them, but you do have free consultation that you could be able to have within 1 hour with each person here that was here today. It does have a 3-month expiration because I'm here and I'm the admin. If you happen to pass, I know 3 months from now is Christmas. So I know we have a lot of things going on. If you happen to pass before the 3 months, just give me a call. But we do really want you to meet them within 3 months. So, but anyhow, before you leave, let me get those signed for you, because without my signature, they're not valid. Along with that, if I could also have the blue sheet, as I mentioned to you, this will be more for Father Michael as well as for the Archbishop to show them that we are here and we are working. Thank you all for coming. Thank you.
Right on time, too.